More now on the Robodebt story, and Rick Morton is a senior reporter with the Saturday paper and a two-time Walkley Award winner for his coverage of the Robodebt Royal Commission. He's extensively covered this story from the very beginning. He knows it back to front. He joins us now from Boonah in Queensland. Rick Morton, g'day. So how do people affected by the Robodebt scheme feel about this decision today?
It's a small relief for them, but it should never have got to this point, according to, parents of people who killed themselves and people who had Robodebts raised against them. They expected the NAC to actually investigate the first time around. They had an open and shut case, they thought, and the NAC, after sitting on it for 11 months, said nothing to see here. So this is now a back to square one moment for them, but it's better than the alternative, which is the caravan of justice moving on without them.
How does this decision today reflect on the processes that the NAC used on this decision?
I think it's terminal for them. I think it shows that they were fundamentally deficient. The error of judgment, which Paul Brereton was found to have engaged in by not properly recusing himself from the entire decision-making process, was a pretty significant one for a former, Supreme Court judge, where, it's not enough to take yourself out of the room for the 3 minutes the decision is made. You have to actually remove the perception of any conflict throughout the entire process. And as the inspector found, he was comprehensively involved before, during and after the October 19 meeting where a decision was made to do nothing about the 6 referrals from the Royal Commission, and in fact allowed the media statement to be partially rewritten by the person about whom he had a conflict through their lawyer, and then accepted those amendments. It's a real problem of perception at this point, and perhaps even more.
But this report or statement today says there was nothing intentional here.
Correct. There's nothing intentional, but they do also... So basically what Gail Furness found was that Paul Brereton engaged in official misconduct, which under the NAC Act is not a breaking of the law. It's not an intentional impropriety. It's an error of law or fact. But it's also not the slip-up they say that he kind of made it out to be. It was substantially kind of significant in terms of the decisions that were made. It wasn't just an issue of process and form. And so it's somewhere in the middle where it's serious enough for the inspector to intervene. In fact, it's not just the inspector, Gail Furness. She got an independent review herself by a former federal court judge, Alan Robertson, who made his own inquiries and came to these conclusions.
Okay, so now let's focus on the people affected by the Robodebt scheme. What does this mean now? An actual NAC investigation is still not guaranteed?
No, it's still not guaranteed. Essentially, the issue is now remitted back to the NAC through an independent person, whoever that might be that they choose to appoint, to then re-examine the issues. And what we do know is that Paul Brereton was the one who engaged legal advice internally through the NAC to look at the merits of this decision. And what that internal legal advice came back with, from what we can tell in the published documents, is that, the findings of the Royal Commission were pretty substantial. They were mostly solid, but they were not free of doubt, which is, of course, true of any findings that you might make in a Royal Commission. And so and they also seemed worried that any decisions that were made about potential corruption or breaches of public trust would be litigated by the individuals to the nth degree, which is, of course, no excuse not to press ahead with something. So now we're back at, will they or won't they? But again, I think the real issue here now is the focus, or the pall that has really fallen over the entire institution, that we could have these decisions made, through these deficient processes, and would never have found out about them were it not for the public blowback and the complaints that were made to the NAC inspector, somehow being kind of waved away as a simple mistake. It's not quite true. And I think we now need to look at the Attorney General and whether, the Parliamentary Oversight Body can do something about the NAC, because it has lost whatever imprimatur it had through really rookie mistakes, I think.
So do you have an opinion on whether Commissioner Paul Brereton should step down?
I think he should. And again, it wouldn't be because it would be an admission of him having done anything intentionally wrong. But, at every step of this process, he has attempted to kind of manage the conflict, but he hasn't gone the whole hog, so to speak. And, the media statement itself that was put out to explain this decision is part of the problem here, because it contained, according to the inspector, and Alan Robertson, the former federal court judge, it contained misleading statements. You know, they said, oh, we don't want to duplicate processes, and the Australian Public Service Commission is looking into this, and they've got sanctions they can attach. But none of the people, or very few of the people that were referred to the NAC, who were also being looked into by the Public Service Commission, would ever have attracted sanctions because they were former public servants. And so that was misleading. And it was misleading as well to say that, you know, there wasn't anything they could do, and that, you know, a minister who was referred to them could also be found, you know, accountable to the Public Service Commission. So there are these real gaping holes in their rationale. The reasoning was specious. And I think Paul Brereton should do the honourable thing and stand down and give the NAC a chance at redemption, because at the moment it will limp along until someone puts it out of its misery.
And this body is just too important?
Well, it is. And people fought for this for a very long time because at the federal level, as you know, there was no national accountability or transparency body. And of course, the politicians never really wanted to do a complete carbon copy of the New South Wales Independent Commission Against Corruption. But that is what the public wanted and expected, for some level of accountability and scrutiny, you know, to be re-injected into the national debate. Ironically, because there was so much to, you know, write home about, which came from the journalists. You know, people breaking stories about misuse of public funds, you know, sports rorts, you know, the sale of land in the Leppington Triangle, you know, on and on and on and on these scandals went, and we had no real agency with any teeth. And in fact, the Royal Commission into Robodebt itself found that the accountability bodies that we did have, the Commonwealth Ombudsman, the Australian National Audit Office, the Information Commissioner, even the Senate, as much as some individual senators tried, none of them were able to lay a finger on Robodebt. In fact, some of them were misled deliberately and allowed themselves to be misled by the public servants they were meant to be keeping in check. And so the NAC was meant to be that thing, and it is thoroughly disappointing because already it was allowed to have carte blanche in terms of whether it wanted to hold secret hearings and never release, you know, too much information to the public. And their public statement about the Robodebt investigation was exactly that. They said, here's what we've decided. The decision's been delegated to a deputy commissioner. We're not going to tell you who it is. And also, we're no longer going to take any questions about it. And they wanted us to all move on. And thankfully, that has not happened.
So what's known about the detail of the allegations against the 6 people referred to the corruption watchdog by the Royal Commission?
Yeah, so this is where it really gets interesting, because we get some hints at what the legal advice at the NAC has come to understand about the Royal Commissioner's findings. And they say that some findings are stronger than others. Some are based on inferences because there is a lack of documentary evidence in some cases, particularly as it relates to the minister. Now, we don't know who the minister is that was referred, but, you know, there's a real gap in what, you know, the lawyers might need to defend, you know, the label of corruption. But they also say that there's no argument that, you know, corruption couldn't be found in these cases. And so already there's an open question about, you know, well, should we go on and investigate? And of course they decided not to, because they thought that there would be no public interest in it. What we do know about some of the individuals that were referred, based on the documents we got today, is that they're having difficulty, they think, proving an abuse of public office, because some of the offences, quote unquote offences, were not offences of proactivity, but of omission. So not making sure the legal advice was up to scratch, not necessarily telling Cabinet about the shaky fundamentals of Robodebt, i.e. the fact that they had legal advice saying this thing was not lawful. And so there seems to be some interpretation going on there about what, you know, how do we prove an offence of omission as opposed to an offence of commission? Again, this is all something that could be, you know, battled out. In fact, you know, the Inspector Gail Finesse found that, you know, there was never any concern about having duplicate inquiries possibly coming to different findings, because, as she pointed out, the Australian Public Service Commission did exactly that. They had no problem doing it. The NAC shouldn't have had any problem doing it either. They just didn't appear to want to press ahead and potentially have the people they were making findings against litigate.
And remind us of the human cost of the Robodebt scheme and exactly what it was.
Yeah, I mean, they came up with an algorithm to wrongly attribute earnings to people on welfare, past and current welfare recipients. And essentially they divided tax office income by 26 and said, you owe us money. when in many of the cases there was no money owed at all, or the debts were vastly inflated. And they knew this. They knew it was mathematically wrong. They had legal advice from December 2014 saying this does not accord with social security legislation, i.e. it's illegal. And they went ahead with it anyway. And even, that was in 2015. And then from 2017, the event horizon beyond which many of the public officials involved can no longer deny they knew about the serious faults in this scheme. There was public opprobrium. There were eminent legal minds saying this is unlawful, this does not accord with the way things are done. People are suffering, people are killing themselves. And people lost family, they lost jobs, they, they developed psychiatric conditions, they were unable to keep the employment they had because they suddenly had this massive debt hanging over their head. They had their tax returns swiped by the government. Welfare details of private individuals were leaked by the former Human Services Minister, Alan Tudge, in what the Royal Commission found was an abuse of his office. It was an horrendous scheme that lasted for 4.5 years before the Federal Court of Australia was able to find, or at least by admission, a case was brought where the Commonwealth finally had to admit that it was unlawful. And now, of course, through the Royal Commission, we have all this evidence of the fact that at every turn, very senior people in 2 departments at least, and potentially the ministers as well, knew significant details or should have known significant details about what they were doing that pointed to them needing to ask more questions, and they didn't do it. And there are other potential cases like, 2 law firms are investigating misfeasance in public office, which is a really hard thing to prove, but it was last proved in the live export trade case where the former Agriculture Minister Joe Ludwig suspended the live cattle export trade to Indonesia for 6 months and catastrophically, ruined half the cattle trade in Australia. And that was an abuse of public office, the Federal Court found. So a similar case is being contemplated in Robodebt.
And so what's your perspective on what is still needed to appropriately compensate people and to hold people to account?
So there was a class action into Robodebt where, again, the Commonwealth admitted it was unlawful, but they settled, and I think they settled strategically and early because that class action never got the key documents that would have allowed us to see this was not a mistake of public admin, but actually a conspiracy at several stages throughout its birth. And the people, there was a $1.8 billion settlement through that class action, but it was to repay $700 million that was recouped from people, so to give them back the money the government stole from them. There was $112 million in interest, which is, again, money that people were owed. And then the government waived the rest in debts that it hadn't yet recouped. But there was no financial compensation for damages, economic, psychiatric, for loss, and otherwise injury. So there has never been injury, loss or compensation for people, even people who managed to, submit their pay slips and do what the government asked them to do. It was at significant personal cost because they had to suddenly do the administration that used to be done by an entire arm of government. And they had to do it themselves, and they had to do it under significant stress. And so a misfeasance in public office case, were it to make it as a class action, could potentially remedy that and at least give some semblance of justice to the people who were hauled through the ringer on this one.
Yeah. And you'll look on with interest at what happens with this investigation at the NAC now and whether that actually goes ahead after this eminent person takes a look at it. Okay, we'll leave it there. Rick Morton, thanks so much for talking to us from Boonah in Queensland.
Thanks, Jay.